Okay, everybody, welcome to Debt Collection Defense Clinic. We will be talking about what to do when you're served with a debt collection lawsuit. It's a lot of information, so I'm going to try to get through it all as quick as I can. But I do want to alert you that at the end of the presentation, we will have contact information for South Carolina Legal Services so that if you do want to get some legal assistance or representation in a debt collection lawsuit, all of that information will be shown at the end of this presentation. Also, we will want to make sure that everyone knows that our services as attorneys are free to eligible applicants, and that information can be accessed on our website as to what will make you eligible for our services. So that is where you'll find that, and there's not a lot of time today to cover that. So let's go ahead and get started. I want to say first that I think it's important to say that the purpose of the clinic presentation is not to provide tricks on how to avoid paying the debt that you actually owe. However, quite often when you are sued, it may seem like it's for a debt that you actually owe. And then if you sort of go through some of the procedures that we'll talk about today, you may discover that it's not a debt that you owe, or it may not be. It may be a debt that you owe, but you don't know owe as much as the creditor is saying in the lawsuit. So there's some things like that that I think are important for you to think about before you actually get into the meat of defending a debt collection lawsuit. I also want to say that we are at South Carolina Legal Services creating a full online classroom in our runthelaw.org site. And this will be a classroom for debt collection in circuit court cases in South Carolina. That is not going to officially launch until January, but we are looking for people to try it out for us before it officially launches and give us feedback about whether it's helpful, if there's things that we can change and so forth. So if any of you are interested in that, you certainly can contact our office here at South Carolina Legal Services. The number here at my office in Greenville is 864-679-3232. And you can ask for me, Susan Ingalls. I'm the senior staff attorney and consumer law unit head. So this is my area of practice. So let's go ahead and get started reviewing the lawsuit process from beginning to end. First, I would like for you to take the poll that you see here. Let me go ahead and launch that poll. Are you joining the webinar by computer, cell phone, or tablet? It's important for us, very helpful to us. Okay, looks like we've got a little bit of both. 50-50. Okay, that's very helpful for us, so thank you. Now, is the device that you are using, is it yours or is it someone else's? That's the wrong one. There we go. Right. Poll number 2. Is the device you're using yours, yes or no? All right. 50-50. Thank you very much. All right. Now, thanks for that information. Now, I want to start out by, this is one of the most important things that I think a lot of people don't know when it comes to debt collection lawsuits. Sometimes you get served with a debt collection lawsuit and you're freaking out, panicking and everything. But it may be that you are what we call judgment proof or judgment collection proof, and that can affect your decision on what you're going to do about the lawsuit. And we'll talk about all the options for participating and not participating in the lawsuit. So it's important to know that 2 things. One is, in South Carolina, there is no wage garnishment for consumer debt. So if you get sued for a credit card or some other kind of loan, that's a consumer debt, and your wages cannot be garnished if a judgment is entered against you for consumer debt in one of these lawsuits. Also, you have exemptions in your property that you own. If you have a home, it can be exempt, and we'll look at those exemptions here in just a little bit. Creditors quite often will push you to make payments on a debt that you may owe, and they may have a judgment against you, but you may not be required to pay it. And that's one thing I think that people don't always understand. If you have a judgment against you, it is the creditor's option to try to collect it from you. It is not necessarily your obligation automatically to pay it. Okay, so here's some of the things that you want to think about when you first get served the lawsuit. Did you understand the process at the beginning? This is really important. Did you know how much you're paying? Lots of times people will come to us and they'll say, I didn't know, I mean, I thought I had paid all of this. And quite often that goes back to the original point of starting the transaction of the loan or getting the credit card, and you thought that you understood the terms and conditions, but you know, maybe they're different from what you expected. Sometimes we don't even realize how much we're going to have to pay. You might know what the monthly payments are, but you don't know how much you're going to pay over the long term. Fees might be added, late charges might be added. So creditors often do take advantage of the fact that not everybody understands what their rights are. So you want to assess your risk in participating in a lawsuit. These are 6 things that I think you need to think about. You know, having the ability to engage in the lawsuit. You need to know if you've got time, transportation. Do you have a computer available? That's particularly important right now, but you know, probably in the future as well. And you know, you want to make sure that you are ready to participate in the lawsuit, because that could be a real grind. Okay, let's go to another poll, because I always like to find out, how has a creditor been treating you, either before or after a lawsuit? You may not have even had a lawsuit filed against you yet, but let's look at how the creditor has treated you. Has it been respectful, demanding, harassing, or threatening? And it looks like most everybody says harassing. So thank you for sharing that. And that's pretty much what we see, that they can be very harassing and pushy. But they can also be some of those other things as well. Here's some of the things that I think are important for you to know about your rights. Most importantly, you have the right to be told the truth. And quite often that doesn't happen. Whether it's you're being told something that is not true, or if you are just being given the impression that something is true when it really isn't. And one of my favorite examples of that is, quite often people are told they're going to go to jail if they don't pay the debt. And, you know, we always say they've outlawed debtor's prison, so you can't go to jail for failure to pay a debt. Now, there's a couple of exceptions to that, like child support and a couple of things like that. But when it comes to consumer debt, credit card collection, loan lawsuit, it's not something you can go to jail for. The other thing that you have the right to is to have your day in court. Quite often people want that. They want that day in court. Now, what they don't always realize is they don't have the right to have an attorney appointed for them. This is particularly true if you are a low-income individual, because our services are free for people who are eligible and who we have an attorney available to represent. It's not like with a public defender in a criminal case, where if you qualify from an income standpoint, you're going to automatically get appointed an attorney. That doesn't happen in a civil case like this. But you do have the right to represent yourself and go to court, and of course to apply for our assistance, which is free. And there are some other opportunities for reduced fees with other law firms. Okay, here's some options you need to consider prior to being sued. So you're getting harassed. The creditor is calling you saying they're going to sue you, or they're going to take your house, or whatever all harassing and threats they're making. You've got some options. Number one, you can just pay the debt. Number two, you can settle the debt. And that means usually settling it for less than what is owed. And that can take many forms. It can be paying a lump sum. It can be making payments toward the debt. And I don't always recommend the payments towards the debt unless it is a set amount and you've got set payments that are going to end at a certain point. And that's why, of course, it's always important to get that in writing. The other thing you can do prior to being sued is to do nothing. Just continue being in default on your payments on the debt. And of course, when you do that, eventually you are probably going to be sued. So let's talk about what your options are after you're sued. Number one, you can ignore the lawsuit. Not recommended. You don't ever want to ignore the lawsuit, because what will happen is the other side will win automatically. It's always surprising to me that sometimes people say, well, I got served with this lawsuit, but I don't owe that. That's not my debt. That's not my credit card. But you have to say that. You have to respond to the lawsuit and say that so that the court can make that sort of a finding. The other options are settle the lawsuit on your own by yourself, representing yourself. You can fight the lawsuit on your own without a lawyer, or you can retain a lawyer to help you settle it, or retain a lawyer to fight the case and represent you fully in the litigation. Okay. Now, I want to show you a little item that we have. Hopefully I can bring it up on the screen here. There we go. Hopefully y'all can see that. This is a little thing that we have called a defeat sheet. And it goes through the basic things that happen in a debt collection lawsuit that you're probably going to be facing. I don't think have time today to go through all the details of all of these. But that's why I invite you to definitely contact us if you are in a situation where you've been sued for a debt, a consumer debt. And also invite you to participate in giving those trial runs on our debt collection online classroom, because all of this is in there and there's a lot of detail about how to do it. So we'll get back to that in a little bit. Hopefully we'll have some time to go through that in detail. Okay, so that little defeat sheet is sort of the process of a lawsuit. So that's what happens, the procedure that happens after you get sued. You know, you have to answer and so on. Now, let's say that a judgment is in. Well, what is that? That's a final decision in the case. Okay. Now, it may be a decision that the credit card company or loan company, whoever has sued you, wins, and they get a judgment for the amount that they sued for after having a trial. Or the judgment can be that that you, as the defendant, win and you owe nothing. Now, there are a lot of other types of judgments that can happen along the way without having that final trial. And that's what's listed here on this slide. There could be a default judgment. That is where you ignore the lawsuit and don't answer. Consent judgment. This is when you negotiate essentially with the creditor or their attorney, and you agree that you owe the debt or you owe some amount of the debt, and you consent to judgment. And then lastly, summary judgment. Now this is what happens in the lawsuit if you did answer, or sometimes even if you were in default, the creditor will ask the court to go ahead and give them the judgment because you can't prove that you don't owe this debt. And they have proven just in the paperwork that they have that you do. And that's what they say, but they have to prove it with proper paperwork. So if they're successful in that, the judge will say, well, there's no reason to go to trial because clearly the creditor has provided sufficient documentation that shows that they are owed this money and that it's you, the defendant, that owe it. But if you have enough proof to show that there's a question about that, maybe there was identity theft, maybe the amount's wrong, maybe this is never a credit card that you have, and you can say that in a sworn affidavit, which, you don't just say it, it has to be true. And so you say that in a sworn affidavit and you file that against their motion for summary judgment. Then that may create a genuine issue of material fact, and that's what we call it, and that's what allows you to move forward from the summary judgment and allows the judge to say, well, no, we're not going to just automatically give them a judgment because they haven't quite fully proved their case. So those are the ways judgments can happen. Now I want to talk about the exemptions, because again, if you get a judgment against you, that doesn't mean that you have to pay it if you are exempt. Okay? So here is the basic South Carolina exemptions. And any of these documents and materials that I'm showing today, we can provide to you if you just email us at webmaster@sclegal.org, and we'll share those with you. Our platform here is not letting us share those in the chat box like we normally would. So anyway, these are the exemptions in South Carolina. And the most important one is your home, the principal residence, and that's the first one on the list. And the exemption amount there is $63,250. That's for one person. And of course, it's double that if you're a married couple that owns a home together. Now, what does exemption mean? Okay, the exemption means that basically that the court can't order your house to be sold to pay this consumer debt judgment. Okay, so here's how you figure the exemption. Let's say you have a house of a value of $80,000, but you have a mortgage of $60,000. Okay, so you only have equity in that house of $20,000. You have to subtract those two, and that's how you figure out whether or not your equity in that house is exempt. So if your equity is $20,000, as you can hopefully see here, $63,250 is that exemption amount. So you would be well within that exemption amount. Well, what that means is that the creditor who has a judgment against you is not going to be able to sell that property. The exemptions don't just include your home. It's one. They also include cars, money in the bank, and other items of household property and tools and things like that. So it's important to know about that, because going back to what we talked about at the very beginning of the presentation, that can mean that you are judgment collection proof. So the creditor may get a judgment against you in the end, but they won't be able to collect it if all of your property is exempt. And as I said at the beginning, your wages can't be garnished. And so you're essentially, protected in your property and in your wages if you have. Okay, so here's what the options are regarding those exemptions. Let's say the creditor has gotten a judgment against you. Well, what if your net value of your property does not exceed that exemption, just like in the example I just gave you? Okay, here's what your options are. Ignore the judgment. Okay? Pay the judgment. Then you can choose not to pay the judgment, and there's some consequences, to not paying the judgment, which is essentially the same as ignoring it. Of course, it will be negative rating on your credit report, but you've already got that situation because you didn't pay the debt, and that's already on your credit report. But again, the other thing is, consideration is that a court's not going to order you to pay the judgment or sell your property or garnish your wages if you meet those exemptions. It's important to know this. The judgment will expire after 10 years. Now, that's a long time, but in some situations, that is helpful to you because it will go away in 10 years. If they don't collect it during that 10 years, then they're not going to be able to collect it from you or force property to be sold or anything like that. So I think that's important for everyone to know. You can also settle the judgment for a lesser amount. So sometimes you can make a payment arrangement if you want to. I don't recommend making a payment arrangement that you can't afford, especially if all your property is exempt. But you can make payments, make some kind of payment arrangement. And then also you can make a lump sum payment that is less than the amount of the judgment. The way I usually see that is someone has the judgment against them and maybe they get a refund when they file their tax return. And so they call the creditor and say, hey, you got a judgment against me for $4,000. I've got, tax refund money and I can pay $2,000 if you're totally satisfied with judgment for that amount. And sometimes you can work out an agreement like that. But always do it in writing and preferably with the help of an attorney to make sure that all those I's are dotted and those T's are crossed. And then finally, you can, of course, discharge the judgment in filing bankruptcy. So that's always an option, but that's kind of the last resort, I think, especially when you're in a situation where your net value is not more than what the exempt amount is. Okay, options when the creditor gets a judgment against you and the net value of your property does exceed that exemption. Again, you can ignore the judgment. You can pay the judgment. If you don't pay the judgment, it will expire after 10 years, and also you can settle it. Now, what happens about the fact that you do have property that exceeds that exempt amount? Well, let's see. And we'll talk about this a little bit more towards the end of this presentation. There's something called supplemental proceedings where a judgment creditor can pursue asking the court to sell your property. So we'll get into those details in just a minute. All right. So here's where we are. You've gotten sued. You've gone through the procedure with our defeat sheet, kind of gone through the case. So let's talk about going back to the filing of the complaint, and you've decided, well, I do want to participate in the lawsuit because I think this isn't my debt or this was identity theft. You'd be surprised how often things like that happen. Or maybe this just isn't a creditor that owns the debt that you owe. Well, what I'd like for you to do right now, just for a minute, think about lawyers you've seen on TV that is like your favorite lawyer. And you think that, boy, if I need a lawyer, that's the one I would want. So I'm going to give you a minute to think about that. And then I want you to channel that person, channel that TV or movie or book lawyer, and think about what they would do, how they would handle this for you. And then just sort of channel them and think about you doing that. And kind of imagine what the outcome would be. If you were the tough attorney that you admire so much on TV, how would you handle your case? And how would you pursue it? I think that's always an important type of exercise to go through when you're considering how to handle representing yourself in a lawsuit. Because you do need to think about that. Think about how a lawyer would act. Think about how to handle things, how to handle discussions with the attorney for the creditor, things like that. If you don't have your own attorney, those are some things you're going to need to think about. And sometimes it'll give you a boost of confidence to just sort of channel one of those TV attorneys. Okay. Now, there's some other ways to handle lawsuits, and one of those is mediation. So mediation is a way that the court brings parties together to try to resolve the lawsuit. So if you wanted to try to resolve it and say, well, I don't owe that much, but I will agree that I owe this debt, but here's how much I owe. You should be able to do that yourself, but that's not always possible. And what a third party mediator does, they're supposed to be objective, and they come together with the two parties, sometimes, with the parties and their lawyers, and they try to help you resolve it and come to some kind of reasonable conclusion. The important thing to remember about mediation is that you're not required to come to an agreement. You can still always go through the whole lawsuit and represent yourself and maybe come out on the other end without a judgment against you. So that's your option. Now, in South Carolina, if you have been sued in circuit court, then that mediation is required in circuit court. Mainly, though, if you file an answer, it's required. So if you're in default, you have not filed an answer, so you're not really participating in the lawsuit, there's no reason to mediate. There wouldn't be anybody to mediate with. So the other thing to know in South Carolina is there are many counties where the magistrate courts require mediation, but typically that's only if you have not only answered the complaint, but you've also asked for a jury trial. And the reason we have so much emphasis on mediation in South Carolina, as there are in other states as well, is that it's helpful to the court system to get cases resolved without a full-scale trial, because there's only so much that the court system can handle these days. And if you can mediate the case and resolve it in an amicable and reasonable fashion, that can be better, not only for the court system, but for the parties as well, you, the defendant, and the creditor also. So mediation can be a helpful tool. Arbitration. Arbitration is different from mediation. What arbitration is a third-party arbitrator acts as the judge. So this is found in many and probably most consumer debt type of contracts. Quite often there is an arbitration clause that requires an arbitration of the case instead of going to court. And you need to really be careful when you sign paperwork in the beginning with transactions to see if there is an arbitration clause, because you might not want to do that. Now, the good thing about arbitration is if the creditor demands arbitration because you have filed a claim back against them in a lawsuit, they have to pay the arbitration filing fees because they're the ones that have put that arbitration clause in there. A couple other things about arbitration is the award from an arbitrator or the arbitrator decision is final. The creditor is going to have it confirmed by the court so that it's a registered judgment with the court system in our state or in the county where you live. Now, they're final. There's very limited circumstances under which an arbitration can be challenged. So it's not like you can appeal an arbitration case. For the most part, those are going to be final and can't really be appealed. Limited circumstances like fraud and misconduct, and again, very limited. The good thing also about arbitration is it quite often does not take as long as it does in court, because the arbitrator is getting paid to do what they do, and they're happy to go ahead and get you into their schedule and get your case completed. So arbitration is not necessarily a bad thing, but most people want to have that, that right to their day in court in a normal fashion. Okay. Now, this slide talks about the post-judgment collection that I referenced earlier. We call them supplemental proceedings. This is just where the creditor says, well, I know this person has a home and maybe it's the value of it exceeds the exemptions, so I want to get my judgment money out of that house or out of, some other excessive amount of money that somebody might have. So they will sue for a post-judgment collection. There's a particular procedure for that, and it starts with what is called an execution against judgment. And that gets served on you by the sheriff of your county that you live in. Not the criminal sheriff, but the civil division of the sheriff's office. And so they will serve you with what's called an execution against judgment. And it's basically a fact-finding mission to find out if you do have any property that is not covered by the exemption. Now, some counties will simply send you a letter and say, we have had this execution filed in our office. You must give us all this information about any assets that you have. And at that point, you know, if you've been sent the letter, you can certainly respond to it. But you have to be really careful in responding to that letter. Quite often people give way too much information. Sometimes they might give personal information that should not be shared, whether it be personal information like your social security number, or I've even seen people trying to explain why they hadn't paid a judgment, talk about that they were in the hospital or they lost their job, or some personal information that can affect them later on. So you got to be careful about filling one of those out. More on that in a moment. The other thing is that the sheriff may serve it on you at your home. He may walk up with his badge and hand you this execution, and you're scared to death because it's the sheriff and it says execution on there. But not to worry, you just have to provide any information that you do have. Now, for both of those, there is a document that you can file called a Notice of Exemptions. And you can fill that out, you can give it to the sheriff, you can file it at the courthouse. And what that does is notify both the sheriff and the creditor that any property that you might have is exempt. Or it's notifying them that you don't have any property that could that would apply. Maybe you're renting your home and you don't own a home. So that notice of exemption can be real helpful. I think it's important because the next step after you respond to that with the sheriff or don't respond, the sheriff simply, in most cases, is going to send that document back to the creditor or their attorney and say, this person has no property that I can sell to pay this judgment. And they will stamp the document nulla bona, is what they call it, and that means there aren't any assets that they can take possession of and sell. And usually in this day and age, they don't typically do that. If it was that situation, then the creditor would have to pay the sheriff for all of the sale proceedings that they would do. So that usually doesn't happen. The next thing that will happen, though, is the creditor will ask the court to order you, the defendant, to appear for an examination of assets. And when you get served with that document, that's a court order that orders you to appear. So you do have to go and appear for that. It will give you a date and time, and you have to go. Sometimes the order to appear will ask or really order that you bring certain documents like bank records or titles to property or deeds to your home or things like that. So if those are documents that you have, certainly bring them. If there's a hardship in getting those, like sometimes bank records, a lot of times people don't have those, and they might have to pay to get them or something of that nature. They don't have a bank account. Anything like that, you can explain when you get to court. And if the judge, feels that your explanation for not having that is not appropriate, then they will tell you you're going to have to come back and bring that documentation. So that's one of the things that you might also have to do. Now, at that hearing, you'll be put on the witness stand, and the creditor's attorney will ask you questions about your property. Do you own a home? Yeah, okay, I do own a home. What's the value of it? And so they'll ask you about all different types of property that you might have, including jewelry. So there's quite a list. And eventually, because so many people, I would say probably the majority of people are exempt from, all their assets are usually within those exemptions because they're pretty reasonable exemptions. Then at the end of the testimony, the judge is going to say, I find that there's no assets that I can order to be sold to pay this judgment. And so you'll leave and nothing's going to happen to you. Nobody's going to put you in jail. Nobody's going to sell your house or any of that. So I think it's important to know about that process because quite often when you go to that hearing, before the hearing starts, the creditor or their attorney will try to get you to agree to some sort of payment. And quite often people will do that because they're scared that the judge is going to put them in jail, or the judge is going to order their house to be sold or something like that. So any kind of payment arrangement, if it can be done before the hearing, it can always also be done most likely after the hearing as well. So if the judge finds that you do have property that could be sold to pay towards the judgment, then you'll have an opportunity to try to work something out on that by not having to sell your house, but to start paying on the judgment in some fashion. So don't be fooled into making a payment arrangement before the court has actually heard your case. I think that's important to know. Okay, so deciding what to do about the lawsuit. In the final analysis, after going through all of those, it's a question of thinking about whether or not you can win. And of course, what would happen if you won or if you lost in particular. And so therefore, should you try? How stressful is it going to be? Do you have what you need in order to be able to pursue the procedure and the process that happens with that lawsuit? It's something to think about, and I hope this guide has helped you to kind of figure that out. Now, I know there may be some questions, and I just want to say we do have a little bit more time, and so let me just see if there's a question. Yeah, what happens if I was never served? I found out about the lawsuit through a third-party attorney offering their services. Well, two things. Let's just go ahead and answer that. If you were never served with a lawsuit, then essentially the judgment is no good. But the being served can be kind of tricky because the rules are that someone at your home who is of age can receive those papers for you, and the law assumes that they will give it to you. So if you have a spouse or an adult child or a relative or friend that's living with you, and they get served with the papers, then that is good enough service on you. Now that's subject, of course, to you being able to show to the court that perhaps they did not get it to you for whatever reason. But it's presumed that they would. If they're living with you, then there's some sort of bond there in which they would give you that lawsuit. Now, if you did not get served and the case went on, there is a motion that you can make to be allowed to answer, or if there's already been a judgment, to vacate the judgment. And the reason you would be vacating the judgment is because you were never served. And so there is a way to try to vacate the judgment and kind of start over. It doesn't mean the lawsuit never happened. And of course, if some attorney came and offered you their services, you of course don't have to use them. You can, but you don't have to. So that's kind of an unusual situation, but it can be done. If you were never served, you can get that judgment vacated and kind of go back to the beginning. So let's look at our defeat sheet again. I think we do have a few minutes and we can look at that and go through it real quickly. Okay. So first thing that happens in a debt collection lawsuit is you've got to respond to the complaint. As we mentioned, you don't want to be in default because they're going to automatically win, and you may have some opportunity to defeat the lawsuit. So first thing you do is answer with a general denial. You're saying, I don't know who you are. I don't know what this debt is. You're going to have to prove that this is a debt that I owe, and that I owe this much. And as we kind of said at the beginning, you got to prove that you own the debt. That happens a lot in debt collection lawsuits because debts are sold, and the entity that is suing you is probably not the credit card company or not the original lender. It's some debt buyer or debt collector who has bought that debt or is collecting it for that first original creditor. Now, there are some things that we call affirmative defenses. There's a whole array of, I think I have a list of about 35 affirmative defenses, much more than we can get into today. But just for a couple of ideas, obviously identity theft is an affirmative defense. There's something called the statute of limitations that's an affirmative defense. So you got a credit card debt and they haven't sued you within 3 years of the last time you made a payment, then they're barred from suing you. So there's some calculation involved with that 3 years, but that's an affirmative defense, and you've got to raise it in your in your answer beyond the general denial. So some of those are like, well, I deny everything, but by the way, here's some reasons why they shouldn't win, and there are reasons in the law. Counterclaims are you suing the debtor or the debt collector back. Maybe you were harassed, mistreated. Maybe they harassed you. They did some unconscionable debt collection when it came to trying to collect from you. Our state has a consumer protection code that prohibits quite a lot of harassing activity, not the least of which is that they can't call you at certain times of day to try to collect the debt. So those are the kind of things that can be sued back for against the creditor that might be helpful to you. Also, a later lawsuit against the creditor, that's also sometimes an option because of those debt collection activities. We have the Federal Fair Debt Collection Practices Act that prohibits certain kinds of debt collection. We also have, as I said, our state consumer protection code that prohibits some of that as well. So sometimes there's the option of not doing it as a counterclaim in the lawsuit where they have sued you, because sometimes they might ask for arbitration or something like that. But also, instead of doing the counterclaims, you can file your own lawsuit later on. But that's something definitely to discuss with an attorney. All right, so after you do your response, the next thing that happens is discovery. And this can be important if you're really serious about defending yourself in the lawsuit. And this is important for you, or if you have an attorney, and for them to do. It's called discovery. This is where both parties can get information from each other. And you can see here the standard items are interrogatories. That's just asking them questions. Who are your witnesses going to be? How did you calculate this amount that you say I owe? Those kinds of things. There's also a request for production of documents. Send me all the documentation you have that shows not only that I owe this debt, but that you, the creditor, own the debt, and you have the right to collect it from me. The third one, let me skip to the fourth one, that's depositions. Typically, if you're representing yourself, you're not going to get into that. You really pretty much have to have an attorney representing you to do that. I think it probably can be done, but it'd be difficult for you to do as a self-represented person. But that's just where you put the witnesses that the other side says they're going to use. You put them under oath and you ask them all the questions that you might ask them in a trial to find out what it is that they're going to say, so you can be ready to defend yourself in a trial. Now, request for admissions is the number C. This is crucial if you're representing yourself, because a standard practice in debt collection lawsuits is that as soon as you have filed an answer, or even sometimes if you haven't filed an answer, the creditor's attorney is going to serve these first three things on you: the interrogatories, request for production of documents, request for admission. Now, you have 30 days to respond to those. All right. Now, those first two, although you definitely want to follow that rule and respond within 30 days, it's possible to get an extension. And typically, if you're a few days late or something like that, it's not going to be an issue. You can just go ahead and send your responses. The request for admissions is a different animal. You have to respond to that within 30 days. And what the creditor's attorney is asking you to do is to admit everything about the case. Okay, admit that they own the debt. Admit that you owe the debt, that it was your credit card, for example. Admit that this is how much you owe, and so forth. All the items that they have to prove in their case, they'll ask you to just admit right off the bat. And you might not be admitting those because you may have some of those affirmative defenses, or you may say, I don't know if this is true. And you, of course, have to give a reason why you don't know or why you think it's not true. But in any event, the thing that I want to warn you about that happens most often with self-represented people is they ignore all that. They get all those documents and it's a big old stack like this, and they say, oh, I got some more papers from the lawyer, and they just put it over in the stack. It's really important that you respond to those requests for admission, because if you don't, they are what we call deemed admitted, and that means that you've admitted everything in the case. It's worse than never answering. It's automatic that they're going to win, and it's really hard to get out if you're not responding to those requests for admission. Sometimes the court will be lenient and give you the opportunity to respond to them after all, but you better have some good answers or they're not going to do that. Okay, now, so that's a little bit about discovery, but I also want to say you have the right to send that same discovery to the creditor, and I think that's important to do as well. Now, they may send you a big old stack of documents that doesn't mean anything, but hopefully if you've got an attorney that's representing you, then that can be a little bit different and can be helpful for you. So you have the right to do the request for production of documents and those kind of standard interrogatories, who your witness is going to be and what are they going to say. You have the right to find that out. They have to answer that. And the next thing that you will have to defeat, or your lawyer will, is a motion for summary judgment. And we talked about that when we were talking about the different kinds of judgments. But that's a very typical thing that will happen next, that a debt collector will ask the court to just say that they automatically win because they have all these documents to prove their case. You have the right to file an affidavit. And in that affidavit, you can, under oath, say, this is not my debt, or 3 years have expired since I last made a payment on this debt, so it's barred. There's any number of things that you can explain to the court why the case should go forward, because there are issues for a judge or a jury to decide with seeing witnesses and having testimony and that sort of thing. In a motion for summary judgment, it's just paperwork. The court's just looking at paperwork. They might be looking at these responses to this discovery. They might be looking at a deposition, or they may just be looking at affidavits. So those can be really important, and you need to be sure if you get served with a motion for summary judgment that you get going with a quick response to that, hopefully with a lawyer, but definitely with your own affidavit. And I will say at this point, we can't represent everybody fully in a case here at South Carolina Legal Services. However, sometimes we can help you just with in the way that we're doing today, explaining how things go and giving you the forms that you may need. And that's what our online classroom is all about. We want to help as many people as possible, but there's only so many of us, so we just can't represent everybody in your case. So here's how we help you. Okay, just a couple of general things about trials. If you get to that point, if you get to the point of a trial, you probably need to make sure you can find a lawyer to help you with that, because you really need to know the rules of civil procedure, and you just can't get that on the internet unless you're watching one of our online classrooms. So, two things I want to say about the trials. Number one, you need to remember the debt collector has the burden of proof. That means they go first in a trial. They have to get in there and they have to prove their case. And then it's your job, if they've proven their case, to rebut that and say, no, that's not true, and here's why. Okay. And if you're in a position when a trial comes up and you really want to go ahead with the trial, but you don't know what's going to happen, or you're scared or whatever, it may be that the creditor's attorney, wants to try to sell it to you, say, oh, well, I know you don't want to have a trial, so why don't you just agree to a judgment or something like that? Well, two things about that. One is if you agree to a judgment without going through the trial, you've saved yourself the angst maybe of having a trial. But if you go through the trial and you lose, what's going to happen? You're going to have that same judgment against you. So if you're really inclined to want to pursue that trial and show that you don't owe that debt, you certainly can go ahead and do that. You have every right to wait and have that judgment issued by the court rather than agreed to by you with the attorney. So I think that's something that you can think about, but there's certainly nothing wrong with working something out. Just be very careful what it is that you agree to do. Don't agree to make payments that you can't afford to make. And keep in mind the fact that you have those exemptions. Sometimes if you agree to make payments, that's a different animal than having a judgment against you and just voluntarily making payments. Two other things important to be reminded of when it comes to a judgment. Either side could get a judgment against them. They could lose, and they may want to appeal because they think they should have won. You may lose, and you want to appeal because you think you should have won. So whoever decides, whoever got the judgment against them has the right to appeal that. Usually, if you get to that point in a debt collection case, there's not an appealable issue because it really is up to the judge based on the evidence. But sometimes there's a legal issue that is appealable. So it's always good to know you've got 30 days from when that judgment is issued. And one other thing I'll mention about that 30-day deadline, if the judge didn't notice something or in his judgment did not take into account something that you thought was really important, you do have the right to ask the judge to amend their ruling and to address that and say why they didn't find in your favor on that. But you only got 10 days to do that. So both of those, I think, is really important at that point to have a lawyer. And then the last thing about the judgment is remembering that it is good for 10 years and then it will expire. So the rest of our defeat sheet is kind of about paying the judgment and all. We've already talked about that a little bit. So I am going to stop here because we're almost at an hour. It does, don't see any other questions, but I'm happy to answer some if anybody else has a question at this time. We've got a few minutes left. And you can just type it there in the question box. Well, while we are waiting for questions, I will just mention to think about your credit report after a judgment is entered, or if you win the case, or if you pay the judgment, or if you even pay the debt prior to the case. Always keep an eye on your credit report, but particularly if you're successful in a case like this, you want to make sure that that is reflected in your credit report because creditor attorneys don't always go back and tidy that up if they lose. Any other questions? All right, let's get out of that. And I want to just now mention for everyone, and again, if you will email webmaster@selegal.org to get a copy of today's presentation, please do that. We're having some difficulty with being able to add the documents for you to download into the platform. So please definitely do that. This is how you apply for our services. And we have a telephone intake. There's a toll-free number. You can call anytime from 9 to 6, Monday through Thursday. I encourage you to do that if you've been sued for debt collection. These are one of the many types of cases that we handle. So you should certainly apply and see if you're eligible, see if we can help you out. You can also apply online, and that's really nice because you can do that anytime. You can do that in the middle of the night if that works for you, for your schedule. And here's the information about that. You can also find that by going to our regular website at sclegal.org. So I definitely invite you to do that. And again, if you're interested in assisting us with reviewing our online question, our new one that's coming out on debt collection defense, I would encourage you to do that. We're definitely inviting people to assist us with that and would love to have you do it. So just let us know. We sure want it to be helpful to folks. Okay, well, that's the conclusion of my presentation, but I will leave this open for just a few minutes more in case there's any other questions. But thank you all for attending today.